ASAP. Bye-bye. All right, the deputy is going to check to make sure that all the jurors are here. We're going to wait for Mr. Stevens to come back, and then we're going to take up everyone's motions.
I've asked you for copies of Mr. Stevens' motion.
Sure.
I've got-
Well, I think one has been tendered to me.
I think I might have given you both, Judge. Let me see.
Thank you, thank you, thank you. Yep.
Sure.
And you've got a copy of Mark's, Judge?
Yes.
Okay.
It's the motion for specific instances of officer conduct. Is that correct?
No, ma'am.
Okay.
It's the motion lemony.
All right, thank you. All right. Court is calling 2024 CR 0170, State of Texas versus John Stephen Meyer. Could I have attorneys announced for the record for the state
Hank Wilkins for the state, Your Honor. Kevin Stone for the state.
and for the defense?
Troy Baird for for John Meyer.
and Mark Stevens.
All right, I'll wait till he gets his phone under control. All right, and are you John Stephen Meyer? All right, so my understanding is there a motion in limine state.
Yes, Your Honor, we filed two motions in limine. The first deals with an ethical disclosure on Deputy Suarez. We're asking that the defense not bring up the subject of those motions in limine, that motion in limine without first approaching, Your Honor.
All right, then you all need to approach, and just so the parties are aware, I don't have any documentation of what the alleged instances of officer conduct are. So one, if somebody can give that to me so that I'll be able to review it. And then defense, with regards to that, before going into that or seeking to go into that, just approach the bench and we will have a hearing out off the record with regards to that.
And my second motion in limine, Judge, is I would like no mention of the disposition of either John Sparks or Melissa Yanez's cases. Both of those individuals were arrested on August 8th as part of the same transaction.
Oh, please remain seated.
Thanks,
Yes.
So I just would like that not mentioned in front of the jury without first approaching the court here.
All right, defense.
Well,
Oh, and you can remain seated, Mr. Stevens. It makes it easier for everyone to hear.
we think that we think that both the facts of these two people, Yanez and Sparks, the facts of their possession are relevant to whether or not John Meyer, the defendant, possessed drugs at the same location on the same day. And therefore that's admissible. We ought to be able to talk about it because they were at the house and they were also in possession of drugs.
All right, so we had a hearing off, well, not a hearing. Both parties informed the court what they would be arguing off the record. And my understanding, and if I'm incorrect, let me know. My understanding is that the state is going to present evidence, or either the defense is going to be allowed to question for evidence to come in that I guess drugs were found in the location where Yanez was. and
Where Sparks.
where Sparks was. So state, correct me if I'm wrong, the only thing you're asking for is you do not want the disposition of those cases brought before the jury.
Yes, Your Honor.
So defense, the court's question for you is whether or not, and state, you should know this as well, whether or not there was some sort of plea agreement reached with regards to John Sparks and Melissa Yanez.
There was not, Your Honor. The charges against John Sparks were dismissed. It is the same, similar facts as John Meyer, but that case was not as strong against John Sparks, so they were dismissed, but it wasn't part of the plea agreement.
All right. And so John Sparks' case, what was the reason for the dismissal?
It was insufficient evidence.
All right. And then Melissa Yanez, what happened with Melissa Yanez's case, if there was one?
Her case is still pending in the DA's office, Judge. I don't know if there's someone in intake who's actively looking at that right now, or if it's just still pending labs. I haven't researched that further, but it is still pending. It hasn't been indicted or dismissed.
So as an officer of the court, you're saying that John Sparks and Melissa Yanez, no agreements were made between the state and those parties?
Right. Yes, Your
All right. Defense?
Your Honor, as far as agreements go, the case law, I believe, is pretty clear that there can be express evidence of an agreement, but also it's always up to the jury to decide. And in this case, we think the particular coincidence of facts is too strong to be merely coincidental. And therefore, the jury ought to know that these two people who were arrested with drugs on the same day as Mr. Meyer was arrested, they, for some reason or other, were not charged. And that could be either they think they're getting a deal, or more importantly, that it shows that the police officer was just flat out wrong, apparently, about arresting both of them. And if he could have been wrong about arresting both of them, he also could have been wrong about arresting John Meyer. So we think it's relevant. It's certainly relevant under Rule 401 and 402. And it's also part of our defense. And if the court will not let us put that evidence on, we're being denied a right to present a defense under the 6th and 14th Amendments of the Constitution.
All right. With regards to, oh, did you want to add something, State?
Judge, I was just going to say that it's not identical cases against these same three individuals. So the fact that one case is dismissed for insufficient evidence, that the facts of that case are not identical to the facts in this case, Judge.
Well, so Judge, though, that the same arrest, the lead detective on the case against John Meyer on August 8th was Officer Salazar. He had made the decision at that time to charge both Meyer and Sparks with possession of drugs that were found in the room he, the officer, believed was associated with each defendant. He claimed that in his police report. And then all of a sudden the DA dismisses their case, except it's not all of a sudden, it's more than a year later on the eve of this trial. That's something the jury needs to hear about because they haven't dismissed Mr. Meyer's case.
All right. So with regards to the motion in limine, the court has not heard any evidence or any proposed evidence from either side that would suggest that the disposition of Yanez's and Sparks' case are relevant or should come in. Of course, things may turn differently once the court hears other testimony, but for now, if defense, you're wishing to question the officer about that, you'll need to approach before anybody goes into that. So my understanding from both parties, and both parties have agreed that the state or the defense will be allowed to present testimony through an officer that drugs were allegedly found in Sparks, I guess, room or location and Yanez's room or location, and that they were arrested or not arrested. I don't know the facts, but as far as the outcome of their cases, you will need to approach on that if anybody wants to go into that. Does everyone understand?
We do, Your Honor.
All right. What's next?
Your Honor, I think it would be appropriate time for me to for the defense to object to the whole Ghanai's incident coming in, to her arrest. They're going to play a videotape. It would be irrelevant to John Myers' guilt or innocence, and yeah, highly prejudicial under Rule 403. So we object now outside the presence of the jury to the state playing the videotape of the traffic stop and subsequent arrest, and the discovery of a large quantity of drugs in her possession on August the 8th.
All right, again, before any video is admitted, you all will have to approach. I don't know if it's relevant or not. I can't tell you if it's more prejudicial than probative without hearing what the proposed evidence is. So before that video is offered, approach. All right, any other motions in limine from the state?
Judge, I don't have a motion in limine, but the defense did file a request for TCIC and NCIC. We don't have any witnesses that aren't either employed by BCSO or employed by the county. So I just wanted to get clarification that we don't need to have those ready, Judge.
The fact that they're employed by the county doesn't mean that they don't have admissible NCIC and TCIC records, Judge. I represent.
All right, state, if you will just run the records or run the background to see if there's anything. And then if it turns out that there's some criminal history, just let defense know. All right. Anything else from the state with regards to motions?
We have a stipulation that I just gave to defense. I don't know if they have some, they probably haven't had time to look at it yet, Judge. Do y'all want to talk about the video, the Salazar video?
Which
The Salazar video.
Yes, absolutely. Your Honor, we have a motion to determine the admissibility of statements by Mr. Meyer. And there is a statement in which he's clearly in custody and he's clearly interrogated, and it's on video. And we believe that there is no waiver of his Fifth and Sixth Amendment rights on that video. And so because there is no waiver, it violates the Miranda Doctrine, Article 38.22 of the Texas Code of Criminal Procedure, and the Fifth and Sixth Amendments to admit a statement from Mr. Meyer that he did not properly waive his rights before giving.
State.
Your Honor, this is on video, and we, of course, will have an opportunity to show it to you later. But this is either the precise wording of the waiver that he's supposed to read out, or it's substantially complies with 3822, and then express waiver of the defendant's rights is not required. That's a Joseph v. State. So it's our opinion that the statement that the defendant made after being read his rights should be admissible, and that video should come in.
All right. Well, I can't make a ruling on that until I see the video. So if that were to be admitted, who is that coming under, and when is that testimony expected?
Deputy Salazar, I hope that we can call him today, Judge. I'm not sure if with the motion to suppress that, that's going to come in before that. I'm not sure what the timeline is on that, Judge, but it's a video that that'll come in with Deputy Salazar.
How long is this video?
It's short. It's 3 minutes, maybe 4 minutes.
Okay. So any other motions in limine that I need to hear?
We had a
From,
witness.
just one second, from the state, any other motions in limine?
No, Your Honor.
Defense, any motions in limine?
No,
All right.
well, no, that's not right, Your Honor. I'm sorry.
Yes, I was saying, I think one was handed to me.
It will, yeah. I appreciate that, Judge.
I mean, one of it is a preliminary determination of admissibility of extraneous evidence. I can't not do that until I hear what the evidence is. All right, and state,
Yes, Your Honor.
with regards to number 3 in their motion, you know, you can't call Mr. Meyer to testify.
Yes, Your Honor.
Inadmissible opinion testimony.
Yes, Your Honor.
You know, you can't comment on his right to remain silent or make any allusion about his remaining silent.
Yes, Your Honor.
They're asking that you not mention that he asked for counsel.
Yes, Your Honor.
And then 911 calls. If there are 911 calls, we'll have to take that up at the time the 911 calls are offered. With regards to hearsay, everybody make their objections and I'll rule on the hearsay. And if nobody has an exception to the hearsay rule, or if it's not determined to be anything but hearsay, then we'll take that up. Character evidence, again, people make your objection. If somebody says they've known somebody for 30 years and somebody wants to take them on voir dire to test their knowledge of a person, you're more than welcome to do so. All right. And then I always tell the jurors not to review any social media. I always stress to them, and I stress this to every jury, that everything that they need to know about the case is to come from inside the courtroom and not to do an investigation on their own. And I do that because as a defense attorney and as a prosecutor, we were actually having a jury deliberate. And then they came out and they said, well, you know, the reason why we found this way is because we actually went out to the location and did this or that. So I always stress to them, no investigation.
Your Honor, could I ask the court to give a particularly strong admonishment as early as possible for and this court will remember the unfortunate incident 3 years ago in this court in which the court did give what I thought was a strong admonishment.
Mm-hmm.
And then the guy went on Google and researched the defendant on Google. And
Okay, I don't remember that, but okay. Yeah, no, I always give a strong admonishment on that. And actually, each time the jury leaves, I give them admonishments.
Judge, the heart of this motion really was in Roman numeral number 1, beginning on page 3. And Mr. Wilkins just informed me that we don't need to worry about that. Of course, there is another pending case against Mr. Meyer, and Mr. Wilkins says he had no intention of using that at phase 1 of any trial. But I would ask him to give his witnesses, because some of those are common witnesses, and I would hope that he would give them a strong insistence that they stay completely away from that other case in November.
Okay.
Yes, Your Honor. Yeah, I filed that just in case we got to punishment. That was the purpose of that, to put the defense on notice that we will be trying to prove up the November arrest on punishment. But before we put anybody up on the stand, I'll remind them we're just here for the August offense stage, Judge.
All right, so we are going to get some testimony in today.
Yes, ma'am.
So, I mean, that's going to happen. So I don't know what you all need to do, but testimony is happening today because the jury is in the back. Do we have all the jurors?
Yes, Your Honor.
So all jurors are present. They were told to be here at 1:30.
Well, Judge, could I've got, I don't know exactly, and here's why we needed to meet with Mr. Wilkins before we start today.
Oh, Mr. Wilkins,
Yes,
meet
ma'am.
with defense.
Yes, ma'am.
All right.
What we need to do though, Judge, is go through the new evidence and find out,
Whether or not it's coming in.
well, whether he's going to offer it and whether or not there's going to be more of it, and at what point does it stop? And what we would do, Judge, is ask the court to just give us the rest of the day to take care of that and to hear the motion to suppress, and then let the jury come back first thing tomorrow.
All right. So you all need to confer with Mr. Wilkins. Some testimony is happening today. And people need to make a determination. This evidence that's being presented, one, is it new? Two, and by new, I mean defense just being made aware of it today. So then the next question becomes whether or not anybody's going to ask that be excluded. I don't know. So you all need to step out and confer. I'm giving you all till 2:30, but the jury will be hearing testimony today. Okay?
And Judge, could we get an idea of what the court intends to do on the motion to suppress? Because that's.
They say they're not calling that witness first.
I don't see how they can not call that witness.
Oh, quite easily. People go out of order all the time. So if you all would go out and confer, because the jury's been here since 1:30, at 2:30, that will put them being here waiting for us for an hour. So if you all will go out and confer, thank you.
Judge, just one thing.
Yes.
Just so that you're aware, we filed a motion to sequester the jury. I want to make sure that you knew about this.
Okay. Thank you.
Yes, ma'am.
My extension.
You're so awesome, Deputy Laura. I appreciate you. Don, are you ready? All right, court is going to call 2017 CR 3765W, State of Texas versus Richard Almaraz. Could I have parties announced for the record for the state?
For the state, Your Honor.
Defense? And are you Mr. Almaraz? I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Richard Almaraz who was placed on deferred adjudication in 2017 CR 3765W for the offense of assault, family choking, strangulation on May 30th, 2017 for a period of 3 years and extended for a total of 2 years? Is that you? All right, state.
Your Honor, on or about the 13th day of January 2022 in Bear County, Texas, the defendant, Richard Almaraz, did then and there consume alcoholic beverages, namely whiskey, in violation of condition number 2.
How do you plead to that? True or not true? State,
And say would waive and abandon the other conditions. Your Honor.
any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor.
Yes.
So the proposed agreement, Your Honor, would be to have essentially an adjudication of guilt with an affirmative finding of family violence, and then terming unsat thereafter, Your Honor. If I'm best phrasing the idea that counsel and I have discussed, Your Honor.
All right, defense?
Subject to court approval, that is our proposal, Your Honor, for disposition and resolution of this. He has 170 days as part of the discussions, and he has 2 times participated in the patient treatment, one of 182 days and another of 153 days. And then going over all of that and coming to a resolution subject to court approval, that is what we're asking the court to.
Probation, what has he completed?
Your Honor, he did successfully complete state ISF status. And his community service hours. And I would like to point out he did pay $415 toward his fees. And I would like to point out that this case expired May 29th of 2022.
All right. Mr. Almaraz, you want to raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. If you're drug tested today, what are the results going to be? And know that you're getting a drug test before I make my ruling. All right, let's do a drug test. Okay, and then I'll come back with my ruling.
Thank you, Judge.
You're welcome. All right. Oh, excuse me. Yeah, we're gonna finish up now. We're gonna go back on the record in 2017 CR 3765W. Probation, what were the results of the UA?
They were negative, Judge.
All right, I'm glad they were negative. You need to continue with this, you understand? All right, so this is what the court is gonna do. The court is going to grant the motion, find you guilty. There's an affirmative finding of family violence. The court is going to sentence you to 140 days in the Bear County Jail under 1244. Court will find that the judgment is satisfied. Is there any objection to me doing this under 1244?
Absolutely not from the state.
All right, and nobody's filing an appeal on that?
No, Your Honor.
Okay. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal, and you are waiving your right to appeal. Right. Because this is a felony conviction, because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. Do not come back here again. You understand? Because, all right, because hopefully you've learned, hopefully you're maintaining your sobriety. Okay, as evidenced by the negative UA. All right.
Yes, I'm sorry.
Oh, and could I see that one more time? And I'll order removal of the GPS.
Thank you.
You're welcome. You're welcome.
Thank you. No, it was just for release.
All right, thank you.
Thank you, Judge.
You're welcome. Thank you. I'm so glad he was negative. Yeah, well, you can mute us.
Yeah.